Today's presentation is titled LawyerCare, Introduction to CyberCare. I'm Karen Blom, Marketing Director of the Medmarc LawyerCare program. On behalf of Medmarc and today's speaker, Michael Lamprecht, thank you for joining us. Michael Lamprecht is President of BDI Solutions. In this capacity, Michael is responsible for developing cyber risk insurance products, loss mitigation, and reinsurance solutions for exposures related to network security and privacy, cyber extortion and crime, multimedia liability, and technology errors and omissions. Michael has over 20 years of experience as a cyber risk insurance consultant, underwriter, and broker. Prior to his current position, Michael led the cyber risk team at Arthur J. Gallagher & Company and was a cyber risk consulting practice leader at Aon. Michael is a three-time winner of the Risk and Insurance Magazine Power Broker Award. He frequently lectures on cyber risk at industry conferences, including the Risk Management Society, Professional Liability Underwriting Society, and American Bar Association. Michael's continuing professional education includes the designation of Associate in Risk Management. Michael worked closely with Medmarc on development of its CyberCare endorsement, and I'm pleased to turn things over to Michael, who will begin today's presentation. Welcome, Michael.
Thank you, Karen. Thank you, everyone, for joining us today for our presentation on cyber risk. I will walk you through cyber risk as it relates to law firms specifically. Then I will discuss the state of the cyber insurance marketplace with respect to law firms, and then I will dig deeper into the Medmarc CyberCare program endorsement and the associated services that go along with it. So let's get started. The first step in any firm's cyber risk evaluation has got to be looking at their own cyber risks. You can do it as an individual entity, as an industry, or just take a generic overview of what you think the exposures are. The insurance industry has a tendency to look at all accounts the same way. They offer the same products to all industries, and we don't necessarily feel that's the best way. We think that the exposures vary radically industry by industry. We believe that law firms stand out as a type of entity that has a greater need for cyber risk than other types of entities, and we feel the exposures would be very different than, say, a manufacturer or a retailer or a bank or a healthcare institution. So when looking at this next slide here, I've listed out the most common cyber perils, otherwise known as threat vectors, things like hackers, viruses, denial of service attacks. Things on this list can be accidental or intentionally dishonest. And when these things happen, it leads to the graphic on the right, the loss types. And you'll see what I've done here is I've divided these into the four known quadrants of losses that can arise out of your cyber perils. In my experience, most of the losses experienced by law firms occur in the upper right quadrant. This is the third-party liability losses in the non-physical or intangible side of the equation. These would be things along the lines of damage to electronic data and others, consequential loss, privacy breaches. That's something that is a very popular topic, breaches of confidentiality, regulatory violations, and things of the like. Now, when you compare this matrix to, let's just say, a retailer, for example, the order of these perils might change significantly, and they might be in different quadrants. For example, on the subject of privacy, which is probably the most popular in other industries, the largest exposure at a retailer is largely considered to be the disclosure of credit card information and the associated fines and penalties that might come from a PCI breach. We don't see that type of activity at law firms. There are some law firms, yes, that do collect credit card information, and some collect a lot of it. But on the whole, the 50,000 law firms across the United States, only a fraction collect any credit card information of significance, more than a couple hundred records at a time. So the privacy breaches have a tendency to fall down the list. When you are trying to evaluate your firm's exposures, we recommend looking at it according to the area of practice that your firm is involved in, the type and size of clients that you have, and the type and quantity of data that you have. More often than not, we find the third-party liability risk associated with law firms is going to be a breach of confidentiality, breach of privilege arising out of your legal services. And on the first-party side, it's generally not going to be something along the lines of business interruption or even reputational damage. More often than not, the claims we see happening at law firms that are the first-party nature will be cyber extortion or theft of your money or your client's money. We see those two types of incidents happen very frequently. With respect to the bottom quadrants on this risk matrix, we don't see these losses happen frequently, if at all, at law firms. Yes, we do see bodily injury happen, but more often than not, that is at a healthcare type of risk. And we do occasionally see physical damage come out of cyber perils as well, but that's more along the lines of utilities, hydroelectric dams, and things of the like. When you're studying these exposures for a law firm, do study all four, but you're probably going to want to stick to the top two. And moving on, we will get into a deeper analysis of law firm cyber risk in a future presentation, but for right now, we just had to keep it fairly high level so we could talk through the cyber risk insurance products as well. For law firms that are entering the cyber risk insurance marketplace, you will find many, many options available. I've tried to simplify it by dividing it into a few key categories. We see that there are two types of policies in general. There are generic cyber risk policies, which are the most common. Cyber risk policies that are generic are written for all industries, but not any one industry specifically. For example, if you went to your insurance company and you would ask for a cyber risk policy, they would give you exactly the same one that they were going to give to a bank, healthcare, manufacturer, retailer. Those are generic policies. The other types are the specific policies, those that have been drafted for a particular industry segment or multiple industry segments. For example, we see a lot of professional services cyber risk policies. They weren't specifically drafted for law firms. They were drafted for law firms, accountants, real estate agents, and similar entities. Likewise, we also see policies, endorsements, and embedded coverage that were designed specifically for a unique industry such as law firms, accountants, and things of the like. When you get past the generic versus the specific, then you need to look at the insurance marketplace and decide who's offering what. Again, I've divided this into two additional categories. One is the standalone cyber risk insurance marketplace. And what that means is they're selling an individual policy, not an endorsement, not coverage that's embedded in another policy. It is a cyber risk policy through and through. The other part is the endorsement or embedded cyber risk coverage in the lawyer's professional liability policy. On the standalone cyber risk insurance marketplace side, I see 18 markets that have dedicated cyber risk products that are available to law firms and other professionals. They have a tendency to offer significantly higher limits than other type of endorsements or embedded coverage. It starts at about $500,000 in limit. It can go all the way up to $25 million with one insurance carrier. There is significantly more excess coverage available if it was necessary. Generally speaking, the coverage available from the standalone marketplace is the broadest available. It will typically be broader than what you might find in an embedded policy or endorsement. And you will have higher deductibles and premiums that go along with that. The standalone coverage market includes all of the modules, which I've listed here: media liability, network security and privacy, the first-party coverage for data restoration, business income, extra expense, the extortion, crime, and brand and reputation coverage. The main drawback, aside from the price and deductible with the standalone marketplace, is that the claims handling can be very complicated. The one issue that we see with law firms specifically is that there are a lot of what we call crossover claims. Claims such as a data breach that could result in a pure E&O type of claim. The question then becomes, do you file that on your lawyer's professional liability? Do you file it on your cyber risk policy? Or do you do both? And more often than not, people are filing it under both. And that's where the claims handling becomes very complicated, and you often find that you have significant gaps between the two policies. On the flip side, talking about the endorsement or the embedded approach, that is the main advantage of the endorsement or embedded approach. You're buying a single policy from one insurance company. It's a lot easier when it comes to handling claims, and there are far less gaps in coverage, generally speaking. With respect to the endorsement embedded marketplace, you're going to find that there are not as many markets. There are 9 lawyers' professional liability markets that also offer embedded or endorsed cyber risk coverage, Medmarc being one of those 9. The limits available are significantly lower for the most part. The limits typically range from about $10,000 up to $250,000. We are absolutely seeing a push upwards in the limits, and we expect the number to be significantly higher in 12 to 24 months. The coverage under these endorsements or embedded coverage, it varies radically. Some of it is very specific to law firms, others is not. Some of the coverage is very broad, and in other cases it's very, very narrow. So you're going to need to be very careful when you're out there shopping for this coverage. There's also 5 additional lawyers' professional liability markets that offer what we call embedded cyber risk coverage, meaning it's in the main body of the policy form. It's not an endorsement. It has a shared limit. Those policies generally offer limits that are in between the dedicated standalone marketplace and the endorsement. You'll see limits up to about $2 million. The coverage is generally fair, although it's usually limited to liability only, and it's not quite as broad as standalone. Again, just emphasizing it's going to be lower limits, lower premiums, less complicated claims handling, but you're also going to have a lot less limit available to you, whereas on the standalone side, it's going to be broader coverage, bigger limits. Moving on, in the last 12 months, we've reevaluated the state of the market. This is for the first quarter of 2017. It will continue to change. Things have improved radically in the last 5 years of the cyber risk marketplace for law firms. The rates are significantly lower than they were 5 years ago. According to my analysis of about 4,000 accounts, if you go back 5 years from today and were to evaluate the rates back then, you would see they're about 45% higher than they are today. So there's been a drastic drop, mostly associated with carriers that are entering the endorsement, cyber endorsement marketplace and offering what they call or term first-time buyer pricing. You know, if you go back 10 years, believe it or not, the premiums were about 150% higher than they are today. So things are really going in the right direction. There are, however, some issues that still need to be sorted out. In my experience, the structure will need a lot of work. We do see a lot of different designs out there today and no commonality amongst the terms and conditions in most policies. Even the jargon used between insurance companies is very different. My partner reminds me every couple of weeks that the language is effectively broken for cyber risk because nobody really seems to understand what any of it means. And a lot of the time that we spend as a company is just educating people on what that jargon means and how it applies in an insurance context. What we expect to see is the emergence of 2 markets in the future. The standalone, which we expect to remain and grow, but we do expect the endorsement and embedded marketplace to be the source of real growth in the future. If you go back 2 or 3 years, there was 1 or 2 carriers offering a cyber risk endorsement. That number has effectively tripled over the last few years. And based on what we're seeing out in the marketplace, it will probably triple again in the next few years. We're going to see a huge growth in that marketplace. The other large issue with the cyber risk insurance marketplace for law firms is the service bundle. Too many insurers are still applying the retail service bundle to these policies. And by service bundle, what I mean are the services that are provided to the clients before a breach happens. We call those pre-breach services. Those would be things like tools, templates, software to prevent losses from happening, as well as the post-breach services, which are mostly claims handling and incident response. The larger problem there is that most of the incident response post-breach services is built solely around the disclosure of credit card or personally identifiable information, and from beginning to end, it's all about dealing with privacy breaches. They make few, if any, allowances for breaches of confidentiality, breaches of privilege, breaches of contract, and I'm not grouping everyone into that mess, but if you look, 9 out of 10 policies out there today that are sold to law firms have almost no accounting on the service bundle side for breaches of privilege, breaches of confidentiality, and things of the like, contractual breaches and so on. It's all about credit card information, personally identifiable information. That needs to change if this market is going to improve. The underwriting is a lot better than it used to be. Ask any cyber risk insurance broker that was around before 2012, and they will tell you that the applications used to be 8 to 15 pages long. And now there are some markets that are attaching the coverage by endorsement with no application at all, and those that offer it on a standalone basis are offering coverage with a 1 to 2 page application. So overall, everything is good. Everything is moving in the right direction. There are still significant improvements to be made, though. Now to the second part of the presentation, and that is a summary of the Medmarc CyberCare Endorsement. I have to be very careful because I often call it a policy, but it's actually an endorsement that is attached to the Medmarc Lawyer's Professional Liability Policy. The coverage was designed very specifically for law firms. It includes the core coverages. This is what we refer to as an entry-level policy or endorsement. It provides just the core coverages and not the additional bells and whistles that have a tendency to drive price. It covers the liability associated with the privacy and confidentiality breaches, the regulatory fines and penalties, and it also covers the first-party data breach response costs. In the event that you've had a breach and you're forced to incur expense for things like forensics, credit monitoring, and so on and so forth, those two things are going to be covered in the endorsement. One of the things that we really tried to do with this endorsement was to simplify the policy language. With all of the new terminology that is being added to these cyber risk policies, they have a tendency to be very, very long. There was one insurance carrier that introduced a new policy in the last 30 days that was 57 pages long. And I don't know anybody that's going to read a policy that's 57 pages long, but you can be sure that in those 57 pages, there's far too much jargon and terminology that's just not necessary. So Karen and I tried to rework this policy language, relying on the existing terms and conditions within the Medmarc Lawyer's Professional Liability Policy and reusing those wherever possible, so we wouldn't have two different definitions of the same thing, which is a common problem in the endorsement style coverages. So we've attempted to make it easy to read, we've attempted to provide the core coverages, and we've attempted to incorporate the law firm specific incident response services. We talked earlier about the pre and post breach services and a lot of the problems that were going on out there. Medmarc has chosen to incorporate law firm specific post breach response services, and we're currently in the process of developing additional pre-breach loss control services and things of the like, tools, templates, content, software, so on and so forth. As of today, there are two endorsements available, LCP 228, which has a $25,000 limit, a $2,500 deductible, and is available at no additional premium. Every policyholder will get the LCP 228 endorsement at no charge on their Medmarc Lawyers Professional Liability policy. There is a larger limit policy or endorsement available. It's a $250,000 limit, $2,500 deductible, and that is subject to an additional premium, which is a minimum of $300. I think you will find that the rating for that $250,000 endorsement is very simple and results in premiums that are usually in the hundreds of dollars. They rarely make it into the thousands of dollars, which is often where the standalone policies start at. Moving on from there into the coverage provided by the program, I mentioned a few minutes ago that it provides mostly third-party liability coverage and some first-party breach response coverage. I wanted to cover this to the extent we possibly can without getting too deep. I think that what we wanted to do the most of in this policy was to protect the policyholder's third-party legal liability exposure. That is by far the largest source of big claims. We do see a lot of frequency on the first-party side, but the $50,000, $75,000, $150,000 claims up to the $10 million claims are almost always third-party liability lawsuits. And generally speaking, those fall into two categories. The privacy breaches, which we've talked about a few slides earlier, that covers the legal liability arising out of data breaches, hackers, viruses, denial of services, lost laptops, accidental disclosure that involves personally identifiable consumer information or confidential information, and this could occur at the law firm or at an outsourced provider. Likewise, the breach of confidentiality, the liability for that is covered by the endorsement under the same circumstances. Unintentional or intentional dishonest disclosure of confidential information by third parties or by the employees of the firm that results in a breach of confidence or a breach of privilege, and that results in liability. Those types of things were designed into the endorsement. As a follow-on to that, we have addressed the subject of PCI violations. That stands for Payment Card Industry Violations. Although most law firms don't collect much of any credit card information, there are some that collect quite a bit of it. So we opted to put in liability for breaches of the PCI terms and conditions. Those are with your credit card providers. They have the ability to unilaterally fine you in the event that you're in noncompliance with those PCI data security standards following a data breach. We incorporated that in as well. We haven't yet seen a lot of people file claims for that, but we expect that at some point in the future we will see those. Some of the larger bells and whistles that we added on were these last two on the slide, which I call failure to warn and wrongful collection. The failure to warn coverage is an area where we've actually seen quite a few incidents happen where, for one reason or another, a firm has suffered a data breach and then has not notified the victims in a timely fashion. Most often that occurs because the firm is working with the authorities to find the culprit before they notify the victims. Oftentimes law enforcement will come to you and ask you not to disclose that data breach to the victims because it would then notify the bad guys that someone's on to them. And we've seen several claims come out of that in the past. So we've attempted to add that on to the endorsement. That is not a coverage that is common on cyber risk policies these days. We do expect to see it in the future as the interest grows. And lastly, wrongful collection. It covers legal liability out of not just the disclosure of private or confidential information, but also the wrongful collection of it. In other industries, this would take a different form, but generally speaking, in the legal industry, this coverage is triggered when law firms are either collecting information from individuals through their website that they're not supposed to be, or through their legal practices, either by hiring a private investigator to collect information or what have you. we haven't seen much in this area, but the wrongful collection exposure is fairly large in web-centric services, so we do expect to see it come over to the legal industry sooner rather than later. Firms that make a business out of being online and publishing information, such as Yahoo or Google, that have even minor inaccuracies in their privacy policy, often get sued for wrongful collection. Moving on from there, we're still talking about third-party legal liability coverage. There are some additional components here that we had wanted to talk about. The first are privacy policy violations. This expands into a larger area. I called out privacy policy violations specifically, but the endorsement covers breach of contract that arises out of data breaches or security breaches. And that's often important to law firms, in my experience, because I found many law firms are now signing contracts with their clients in which they are assuming liability for data breaches. This is especially prevalent in law firms that have clients that are healthcare related or financial services related. They're being forced to sign what's called business associate agreements, and they're being forced to assume unlimited liability for data breaches that happen at the firm. So we wanted to build in coverage for breach of contract, and that extends to privacy policy violations or breach of a confidentiality clause or indemnity agreement in the contracts that the firms are signing with their clients. We feel that is particularly important to law firms. Their lifeblood comes from those contracts with clients, and many of the cyber risk policies specifically exclude that exposure. We just didn't feel like that was fair when it came to the legal industry. Moving forward from there, there is broad coverage, what I term broad coverage for regulatory violations, and that comes from liability arising out of breaches of regulations or laws that are related to three main categories: the collection, storage, use, security of disposal or private information. Excuse me, I just totally missaid that. Collection, storage, security, use, or disposal of private information, identity theft protection, and notification of actual or possible privacy breaches. Each one of these categories has several regulations or laws that are already in place or in process that are being published relative to these things. So we're trying to cover three broad categories of regulatory violations. On a related note, the policy doesn't just cover the regulatory violations, it also covers the administrative and disciplinary proceedings that are related to the legal industry. Again, we felt like that was quite important to add that, as oftentimes the first point of loss for a law firm is not going to be the FTC. It might be the ADRC or something similar, the ABA. So we built that in there as well. And getting to the end here, there's coverage for data loss or damage. And what that means is if you damage the data of a third party or your client and they need to rebuild it or they lose some value as a result of that data not being there anymore, you'll have coverage for that. More often than not, those losses take the form of our clients accidentally having sent a virus to someone else, or an employee at one of our clients intentionally hacking into an old employer and doing damage or stealing information. At law firms, we find that the employee exposure is also there, but we've had a few cases where law firms that were responsible for holding sensitive electronic information that was being held as evidence or something else, accidentally having deleted it and suffering liability as a result. So we expanded out that coverage as well. Computer attacks builds on the data loss or damage coverage. If you have a computer system that has been breached either by a third party or an employee, and that computer system is used to launch attacks against other computer systems, the policy is intended to respond to that. Again, more often than not, that simply takes the form of having a rogue employee using the firm's computer system to attack others. Could be an old employer, could be an ex-partner of theirs, it could really be anything. We don't know why they do these things. And then lastly, the media liability. This is not very commonly known as a cyber risk coverage, but most of the cyber policies, if not all of the standalone cyber risk policies, cover what's called publisher's liability, errors and omissions that occur in the course of your publications. And there's a bit of a crossover exposure here between the lawyer's professional liability policy and the cyber risk coverage. Many lawyers' professional liability policies provide personal and advertising injury coverage in addition to the pure errors and omissions, and that often clashes directly with the multimedia liability coverage in cyber risk policies. So we attempted to dovetail the two coverages together to provide some media liability coverage in the cyber risk endorsement, but not in a way that clashed with the personal and advertising injury, the limited amount of it that was in the main body of the lawyer's professional liability form at Medmarc. Now, the first-party coverage component of this policy is not a traditional first-party coverage. When people think of first-party coverage, they think of property damage, damage to a building, or a loss of income, or theft. This first-party coverage is for intangible losses, such as a data breach that causes the firm to need to respond to that. We call it data breach expense coverage. The third-party liability component of this policy covers data breaches that result in privacy or confidentiality breaches and similar items. The first-party coverage protects the firm for the cost of cleaning up those losses. So, for example, in the event that the firm suffered a breach of confidentiality involving client information that was due to someone hacking into the system and stealing the information, then the policy would provide the law firm with access to the following expenses: forensics to identify the source and scope of the breach, along with that, putting the system back to where it was, if that is incorporated into the loss. In some cases, someone has actually unlocked the digital lock, so to speak. Relocking it would be addressed in that forensics component. Legal counsel to advise on the applicability and actions necessary to comply with the law firm's requirements, which go beyond what most firms must do. Law firms have ethical, professional, and regulatory requirements, and most firms only have the regulatory requirements. So we built in specific coverage for ethical and professional breaches, and that is one of the large differentiators in this cyber endorsement versus other cyber coverage out there in the industry today. Again, we talked several minutes ago about most cyber risk policies only providing data breach response when it comes to privacy breaches, and that applies to everything we see on the list here, but only with respect to a privacy breach, not a breach of confidentiality, whereas the Medmarc endorsement covers both confidentiality breaches and privacy breaches. And the types of services that you're going to need to address those, they might not be radically different, but the nuances, they can be significant at times. One example that I can think of is if you were to lose a credit card, you would need to notify the individual according to state law, and it would take the form of a paper letter. You'd send it out to them. It would cost you a couple dollars to type and print and mail the letter. You might provide them with credit monitoring service. You'd be looking at $25 to $35 a head. However, on the law firm side, if you were to lose one case file with significant confidential information in it, it might not be $35 to notify the individual and clean up the mess you've created. It might be $35,000. What we see often at law firms is they don't have the same volume of information that you have at other places, but the individual records that they have are far more valuable and more difficult to clean up. Anyways, getting through this list quickly, there's forensics coverage for someone to come in and identify the source and scope of the breach. The legal counsel, someone to advise you on what you need to do following a breach. The cost of notifying the individuals, the victims of the data breach. the credit monitoring service, if it's applicable, and finally the public relations. Most of the dollars that we see get spent on this first-party expense coverage come directly out of the forensics and legal counsel. We do occasionally see notification expense under item C here, but we rarely, if ever, see the credit monitoring. Okay, now I'm trying to change the slide. Okay, did it. Moving to the last component of the presentation, and that is what we're calling the CyberCare Services. Discussed several minutes ago about the pre- and the post-breach services. We are attempting to offer both through the Medicaid, excuse me, Medmarc Cyber Risk Endorsement. The pre-breach services are still underway. That is going to be the subject of a future presentation. We are building out a website that has access to self-directed tools where you'll be able to go and take an information security assessment to determine how well you stack up against published standards such as ISO 17799. We'll also provide you with access to several templates such as a privacy policy, a security policy, a data breach response plan, and similar. And we, depending on how far we go with it, we're not sure yet, we may provide you with access to software loss control tools, things such as antivirus, firewall, and things of the like. That is still up in the air at this point, but we are proceeding down a path of creating a law firm specific loss control website for the Medmarc customers. The second half of that is the incident response services. And we talked briefly about this one slide ago when it came to what's covered by the policy. We give the policyholders the option to make use of our panel at any time they've had a claim. Now, they're not required to use everyone on our panel. Much of it is optional, but we've put together a team of experts, legal and technical experts, that will help the firm handle a claim from soup to nuts, from beginning to end on the data breach response services. The first call is to an incident advisor, and that incident advisor will stay with you and walk you through the entire process. And that goes from the forensics, the notifications, the legal advice, and the public relations component of that. More often than not, we don't get to the public relations component. It is there if you need it, but what you will likely see for your clients is the first three arrows on the chevron. You'll see the access to the incident advisor, the forensics, and the notification services. 90% of the time, the incident is wiped up in that small area. We do occasionally see remediation. That is in the form of the credit monitoring, the identity theft, and the fraud resolution hotlines. You will see that the services we provide in this regard would be very similar to what you see at other insurance carriers. However, instead of just being aimed at the privacy breaches, it also applies to the confidentiality breaches. There are additional services that are not mentioned on this slide. I could not fit quite everything on there, but that covers the majority of it. Again, we will be hosting one or more webinars in the future that dig in deeper to these areas, particularly with respect to things like the website. But for now, that's going to have to be it.